Good afternoon, folks. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna, PC. Today is September 30th, 2021. This is our community conference call held every other week, every other Thursday. We will answer the questions that have already been posted, and if the time permits, we will take on other questions. Within the posted questions, I would have to take the frequently asked questions first. If you have any follow-up questions, you're welcome to ask them, but no new questions until I'm finished with answering all the posted questions first. Okay, before I proceed further, just want to make sure you can hear me okay. So let's do a quick check on the sound.
The conference is now in conversation mode.
Hi, can you all hear me okay, guys? Hello? Say yes. No?
Hello.
Okay, you can hear me all right? Hello? Hello, can you hear me? That's odd.
Hello, do we have call today?
Yes.
Rajiv.
One second. For some reason, you guys can't hear me. One second. Can you hear me
Line
okay?
unmuted.
Can you guys hear me all right? Hello?
Yes, Rajiv.
Okay, sorry. I actually accidentally unmuted all of you and muted myself. All right, let's get started. Let me just double check, make sure I'm doing this right. Presentation.
The conference is now in presentation mode.
Excellent. I am unmuted. All right, let's get started. So, as I have said, which you didn't hear, basically, I'm doing the frequently asked questions first, and then we'll deal with, if time remains, we'll first deal with all the posted questions, and then we'll go on to new questions if there is time. So the first frequently asked question is actually a little bit different than what I am answering, but I'm covering both sides. So the idea here is we've got Jamil, who's got the green card in process, almost there, family-based green card, but also taking classes remotely in a community college. So the question is, can I tell the consulate to hurry up my green card process because I have school going on? And the answer is probably not. You can ask. But more important question is, and this is what we do get asked quite a lot, can I get a tourist visa, visitor's visa, J1 visa, or F1 student visa if my green card is in the process? And that question is very difficult to answer in the abstract. Let us say that the consulate does have discretion to grant a non-immigrant visa even though your green card is pending. There are some visas that are exempt from this problem altogether. H1, H4, L1, L2, O1, O2, E3 visas. These are usually immune from the problem of a green card pending because non-immigrant intention is not paramount in these cases. But for cases like visitor's visa, student visa, J1 visa, you need to have non-immigrant intent. Nevertheless, there are thousands of examples where the consulate does exercise discretion in favor of an applicant where appropriate. We've had cases of spouses of US citizens being allowed to travel on a tourist visa, even while their green card was pending. Same for citizens' spouses. Same for young, what we call legal dreamers, people whose parents have been in the United States for years and the kids have aged out, they've gone to be 21 or older. For those students, they have often given student visas even though their green cards are pending. So to answer Jamil's question, can you expedite your green card based upon a pending student situation? Probably not. Can you be given a student visa? Would that be worth a try? You can try and then you can come back for an interview when the consulate is good and ready to start. But I'll tell you this though, consulates have indicated that they are going to frontline family-based immigration dedicated to family unity first, but within those there are certain categories which you might not be under, but worth trying anyway. So go ahead and try to get an expedite and then try to get a student visa. May work. Any follow-up question on this, press *5. Any follow-up question on this, press *5 on your phone, please. Hearing none, let's go on to the next one. And this is also an important question that gets asked a lot. Continuing to use H-1B when I return on advance parole. So you are on H-1B, you have an I-485 adjustment of status pending, last step of the green card. You've got an advance parole. So the question is, when I travel outside the United States, am I required to get an H-1B visa, or can I return on advance parole and still be considered on H-1B? The answer is, it's great if you have the time and you can actually get the H-1B visa. But if you cannot, what you can do, you can return on the advance parole, and if you are coming to take up the same job which you had when you left, and that job was an H-1B, on a continuing H-1B, government will still consider you to be on H-1B. So returning on advance parole to take up the same job which you left on H-1B is considered to be continuation of that H-1B. You can do H-1B extensions, transfers, etc. once you are here. Okay. So *5 if you have a follow-up question. I think I have covered everything that Nick asked. Okay. The next question is from Praveen about nuances of changing employers during the green card process. So if your employer A filed your green card, then you move to employer B with approved I-140, and H-1B is valid till 2023, the new employer has not yet filed a green card. So you cannot apply for, the answer to your question is, first of all, you have to be in the United States to apply for your adjustment of status. Second, in your case, because no new green card was started, your old employer must offer you the same job which you have to go and join eventually, or at least have the intention to join in good faith. So you need employer A to offer you honestly and in good faith the same job. Can you process a green card without joining them? Well, as long as you have the intention and they have the intention, and if you are asked the question why you haven't joined them, you have a good explanation for it, you can actually have a 485 filed through a job offer from the employer A, the same job which was the basis of your green card. If you don't have that, you cannot file a 485. You can only file for 485/adjustment of status when your priority date is current and the job that is the basis of the green card is available to you right then. Okay? After 180 days of the 485 pendency, you may never have to join the old employer because you can take a same or similar job anywhere. But just make sure that you have the good faith, honest intention of joining the old employer when you file the 485. *5, if you have a follow-up question on this, press *5. Okay, let's go on to the next frequent. Oh, there is one. All right, let's take that. This is from area code 508. 508, where are you calling from?
Yeah, I'm calling from India.
Okay, go ahead.
So I need to join the old employer in case that would be the faster option, right? In case
Yes.
As per the
Yes. Yes. So the point is, you actually don't have to join them. You have to have the good faith intention to join them. Now, this is a difficult case. Why? Because government could validly ask, if you have the intention to join them, why not join them now? But just to take a hypothetical example, There could be a problem of finishing up your current projects. I actually had a consultation yesterday about this. The gentleman was finishing up his projects and he needed a few weeks more to finish the projects. So in a case like that, I think it's perfectly reasonable to say I will join as soon as I can, but I have the intention to join. Okay.
Okay. So I can join them in case the EAD comes, and then it forms the intention that
joining them.
I intend to join them in.
Yes, sir. Joining them is the ultimate proof of your intention to join them. When you actually have done the task which you are required to prove by intent, obviously the proof that you've already joined is enough, right?
Okay. Yeah.
Anything else?
Okay. Yeah. Thanks a lot.
You're welcome. Good luck. Okay, so next we look at the next frequently asked questions. So here the question is from Akriti, says, green card holder working on multiple jobs, is it legal? So I've got my green card 2 days ago. I work 40 hours a week in an IT company as a full-time software engineer, 8 to 5 Monday to Friday. Can I work on another full-time job from 8 a.m. to 5 p.m. at the same time? I can manage because I'm working remotely, and the answer is there is no law that prevents you from doing that. So just because you've received your green card just a couple of days ago, there is no reason why you cannot work on 2 jobs. That question is simple enough to answer. Okay. It is, as far as I'm concerned, it looks perfectly legal to me. Second question, while I'm employed, excuse me. Second question, while I'm employed with company A full-time, can I work for another part-time IT job like 20 hours? Sure. You can work part-time or full-time. Third question, can I work on another non-IT full-time job or non-IT part-time job? So now the questions have changed to not only just doing the job that got you your green card and related jobs. What can I do a completely unrelated job? For example, can I own a gas station or even work at a gas station? The answer is sure. I don't see any problem with that. So you need to understand how the green card process has evolved and how the theory has evolved. It used to be that if you received your green card approval and you left too early after that, government could come back at you saying that it looks like you had no intention to work here forever. And basically, that's just an incorrect interpretation of the law. The law says permanent. Permanent doesn't mean forever. It simply means on the day you got your green card, you had no intention to quit any time in the future. But if 2 days later a great job comes along, I think you can change. You can take it. I don't think anybody can stop you from taking it. Because on the day you got your approval, you had no intention to leave. This supposition that you are required to have this intention has been further diluted by the AC-21 rule that allows you to change to a same or similar job even after 180 days of pendency of your 485. So therefore, I believe if you wanted to take up a second job, not leaving your main job that got you your green card, you could do it. Could you do it part-time? Sure. Could you do it full-time? Could you even do an unrelated job simultaneously? I think you could. *5 if you have a follow-up question. *5. Okay. Here's another one that we get asked a lot. How many number of days can a green card holder stay outside USA? Continuously per year and non-continuously per year. Well, before we get there, you have to understand what a green card requires. A green card requires you to have your permanent home in the United States. So a lot of people might think that, oh, if I keep coming back to the United States before 6 months have expired, I'm keeping my green card. No, the answer is not really. If you ever leave the United States with an intent not to return shortly, you could potentially lose your green card. When you've been outside for 1 year, you lose your green card automatically. Unless you have some very good explanation which you can then take to the consulate and try to get what is referred to as an SB, S as in Sammy, B as in boy, SB1 visa or returning resident permit, where you convince the consulate, I was stuck outside for 1 year because I had a problem. For example, medical emergency, some kind of diagnosis that required extended treatment. If, on the other hand, you do not have your permanent home in the United States and you're just coming for a few days every few months, that's not good enough. You could lose your green card anytime the government so chooses. Okay? So, but the conventional wisdom says, and again, I strongly disagree that the conventional wisdom is absolute because there are so many exceptions to this rule. Conventional wisdom says you should not be gone more than 180 continuous days at any one point of time. Less than 180 days, you are not treated as seeking admission. That's just a technical matter, but it can create problems for you. More than 180 days, you are treated as seeking admission. So everything about your case can be evaluated. My advice is to have your permanent home in the United States. And if you think you might need to leave for extended periods of time, apply for something called a re-entry permit. The scope of that discussion is beyond this question, but look into re-entry permit if you're going to be gone for extended periods of time. Star 5. Oh, I see there's another question. Okay. So to summarize, anytime you're gone for 6 months or more, I think it's more than 6 months or 6 months or more, you could be questioned very closely. Your permanent home must be in the United States. Next frequently asked question, effect of career change on naturalization process and timing. I'm in the field A, I've got my green card, I want to change to career B, totally unrelated. Is there a safe time frame to do this? Well, I'm not sure there really is such a time frame. As long as on the date you received your green card approval, you had no such intention, I think you're okay changing. But if you can wait, as long as you can wait a few months, probably would be a good idea. And I don't think there can be any complications because you're not a slave to your profession. You can do the best you can, hold on to that job, but if some other field attracts you, for example, I have a client who, I believe he was a journalist, yes. So he was a journalist, and from being a journalist, science journalist, he went on to become a play director, I believe now. So he directs dramas and theater. I don't see any problem with that if he did that after he got his green card. So I personally think wait as long as you can and then change careers if that's what you want. Star 5 if you have a follow-up question. But there's no rule of thumb in these cases. Each case is unique. Most important, you should not have a preconceived intention. Area code 570, I believe that's Pennsylvania. 570, are you Pennsylvania?
Yes, Rajiv. Good afternoon. How are you?
Good afternoon, sir. Go ahead.
So, for the same question, in case like during naturalization, if US is coming back and creating some queries, so in your experience, did any of your clients got that query, and then to resolving that query, do I need to spend a lot of money? Can you give me like a ballpark?
Well, we've never had this issue come up in the 30 years I've been in practice. So can this theoretically come up? Sure. Is there a practical way to answer? I think so. Can they make it complicated? They can. So how much money you would have to spend fighting? It depends upon how serious the problem is that they create. Personally, I think it's a minor issue. But again, I would not want to preempt the USCIS's right to question anything that you do. But I think the way the laws are set up, USCIS has a very weak position to ask these questions. Okay.
So just in case, if we are not able to win the case, will they take away my green card or they will not give me a citizenship? What will be the scenario?
They can do both. They can do both. But
Oh.
to take away your green card, they would have to take you before an immigration court. Because once your adjustment of status passes the 5-year mark, they can't just cancel the adjustment. They have to take you to immigration court, where you get to explain your case to an immigration judge. Okay?
Okay, and based on my documents or anything, judge can decide what to do at that point.
That is correct. So it's not just as simple as USCIS revoking your green card with just a notice. They can do that before 5 years of your adjustment is up. So if you got your green card approval today, you are only at risk for 5 years. After that, they have to take you to court. Okay?
Got it. Okay, Rajiv. Thank you very much.
You're welcome. Good luck, sir. Okay, so then, do we have any other frequently asked questions? We do not. Let's go to the non-frequently asked questions, the routine questions. And let's see. The first one is about diversity and F4. Diversity and F4 visa. I preface the diversity visa by saying that we don't process any diversity visas because we don't think you need a lawyer for these cases, not ordinarily. So we haven't done one in decades. I did a couple when it first started, then we realized we don't really need a lawyer for this. So I'll do my best to answer the questions. My daughter, Win DV 2022. Also, her name is in my F4 visa petition. Okay, I have no idea what you're asking me. If she will DV 2022 visa interview in 6 months, when I have to remove her name from, or... Okay, I think I kind of understand. I'm not sure I follow your question. But you can have green card pending in more than one categories. Okay, you can have your green card pending in multiple categories. Whichever comes first, you can take that, and the other one should be discontinued by the government automatically. Okay. *5 if you have a follow-up question on this. *5. Okay. So this one, I think we actually talked today. So here the question was, can 485 be expedited based upon urgent travel need? And I told this gentleman that, again, I've never known a 485 to be expedited. Of course, a 485 can never be expedited if the dates are not current. So if the dates are current, you can try, and we talked today, no harm in at least trying. And if you do not travel after getting your green card, is that an issue? And I don't think it is. As long as you acted in honest good faith, I think that's okay. If you made a misrepresentation or something to the government, that could be a problem for you. Okay. Will they audit? They usually don't, but why do something that can land you not only losing your green card, but being barred from entering the United States forever? So don't just make things up unless they are true. *5 if you have a follow-up question. And something very similar was asked, but not these questions. I did a consultation today. *5 if you have a follow-up question. Okay. So here is a question about I-9 from Sneha. Husband got green card 2 weeks ago, working for the same employer. His employer said he needs to resubmit I-9 because he got his green card. Is this going to be a problem if we do it after 2 months? It should be done as quickly as possible. But it's not really your burden, it's the employer's burden. Okay? And you should not delay it. I don't see the point of delaying it. I don't think you'll be in trouble, and really it's the employer's problem. Employee does not get into trouble for I-9s. *5 if you have a follow-up question. *5. Okay. Then we go on to the next non-frequently asked question. Can an F1 student apply for a diversity visa leaving an employer after approval of green card and starting business? The answer is, first of all, this has never been clear, to me at least, because we don't do diversity visas. But I do know students who apply for diversity visas all the time. So there must be some law out there on this or policy. I do not know. I know that people do apply. Once you get your green card, you can definitely leave. There is no problem after that. We don't do DV lottery cases, so I don't know a lot about this area of the law. And I did already discuss how and when can you leave an employment-based employer. We've discussed this in detail today. What happens if one company applied for my green card, then I shifted to another? Well, that's fine if you do it after your 485 has been pending 180 days and the jobs are same or similar. Is the F1 visa still a single intent visa? Yes, it is. But how does it interplay with DV lottery? I do not know the answer to that question, but I do know lots of students who apply for DV visas. Okay, so somebody needs to take a look at the law and policy on this. I haven't researched this issue specifically. *5, if you have a follow-up question on this, press *5. Okay, this one is from California. California, go ahead with your question, please.
Hi there. Hi, Rajiv. Thank you for your time. Can you hear me?
I cannot hear you very well. If you speak a little slow, I might be able to catch what you're saying.
Yes. Thank you for your time. And I have questions regarding about changing a job after a green card. I recently obtained a green card, the employment-based unskilled worker at a food rep. And I joined the restaurant and worked for a restaurant for about like 3 weeks from now. But the employer required me to work overtime on the Saturday and also on the holiday too. So I want to quit that job. Can I do that?
Well, there are cases where the employer asked for terms that the employee had not agreed to. Okay, so you should have your immigration lawyers look at your file, make sure that requirement of working overtime was not a part of your green card process already, because sometimes it is there in the green card application. So if the requirement was not there and it came as a surprise to you, I personally think you should be okay to leave, but it should be discussed with your immigration lawyers in detail. Okay?
Oh yes, because on the I-45J that that the employer filed for me, they're not anything said about.
Yeah, I don't want to. I want your lawyers to look at your entire file. Was there any indication that overtime, etc., is a part of the job requirements? Some would argue that if you work in the restaurant industry, overtime is normal and working Saturdays is normal. But did you really bargain for that? So it's not a question I can answer without more context. Your lawyers can, though. At least theoretically, what I told you was this. If employer imposes new obligations on you after you get your green card, which you hadn't agreed to or expected, I think you are well within your rights to leave that employer. Okay?
All right. Thank you so much.
You're welcome, sir.
Have a good day.
Good luck.
Yes,
Bye-bye. Okay. Area code 415. Where are you calling from? 415. Okay. 415. Where are you calling from?
I'm calling from San Francisco. Can you hear me now?
Yes, sir. We can. Go ahead, please. How can I help you?
Yeah. Hi, Rajiv. Hopefully you're doing good. So I have a quick question. I'm in the middle of changing my employer, H1. I'm currently on H1.
Okay, hang on 1 second. Hang on 1 second. You'll have to wait until I'm done answering the posted questions. We'll have time to answer new questions, okay? Stand by. So no new questions, just follow-ups, please. Okay, so we did this one. Oh, is the F1 visa still a single intent visa? Yes, it is. We covered that. Now we come to question number 12, which is basically the last 3 questions. 3 questions. PERM in EB2, my priority date is October 2013. Oh, they want to hire us. Okay, sorry. You can just send us an email, sir or ma'am. You can send us an email to help@immigration.com. help@immigration.com. Just copy and paste the content. And our office, that is actually my personal email, help@immigration.com. I'll have somebody respond to all your questions. Okay. By the way, most of our fees are posted on our website. So if you go to immigration.com and look at the very top ribbon, on that our fees are there, about us, contact us, etc. And then there's our fees. You can take a look. Okay. Then we come to Day 1 CPT and H-4 EAD. What are the risks of going on Day 1 CPT? Go to my blog on immigration.com. Okay. Go to immigration.com, go to my blog. In the last 14 or 15 entries, I've written a blog entry on CPT, OPT, STEM OPT. Read there. I have given a fairly lengthy discussion of what the Day 1 CPT is and what the issues, etc. are. So H4 plus EAD, litigation on delays is very difficult to predict. We have stopped doing that simply because, at least in Washington, D.C., if we file a case for a delay that occurred in Texas, for example, government moves to have the case transferred to Texas, and you waste time and money that we spent in filing the case in D.C. You can try talking to local lawyers where you are and see if litigation is an option. But I'm finding out, at least in my opinion, for H4 EAD at least, litigations have a spotty history of success. Some of the ones that we filed in the beginning were all successful. They were all settled. But now I do not know. I think they are a long shot. Oh, *5 if you have a follow-up question. *5. Okay. Area code 412. Area code 412. Where are you calling from?
I'm calling from Mountain View. Hi, Rajiv.
Mountain View, California. How are you, sir?
I'm good. How are you?
Good. So what is the question I can answer for you?
So basically, I wanted to ask you, there are a couple of lawyers, those are willing to file the lawsuit for the H4 and H4 EAD delays.
Mm-hmm.
I just wanted to understand, if there is a success, how much time would it take, to get a response from the
Oh,
government?
that's so difficult so difficult to predict. There is absolutely zero guarantee that it will be done within a few weeks or a few months, unless the government decides to settle. Because if you get into a fight, the case could go on for months, maybe a year or plus. So it all depends upon, if the government settles the case, it could be settled within a couple of weeks. But I don't see them settling these cases any longer. Okay.
Okay. And would you have any comment on the premium processing that the government was about to, sort of...
Well, the law was passed. The law was passed, but USCIS has not implemented that yet. Okay. Pretty much everything before the USCIS was tied to be expedited, but government never implemented any additional expedited processing, premium processings. All right?
Yeah, okay. Thank you. Thank you
luck.
very much.
Good luck. Okay. So next, EB2 to EB3 and I-140 downgrade. Joined new company, filed EB2. Now they are filing PERM EB2 to retain my old priority date. How many days PERM is coming? Nobody knows. If you don't get audited, maybe 5-6 months, a little bit more, a little bit less. Best strategy? Oh yeah, this is the way to do it. You file your PERM in EB2, and then if it is advantageous when your PERM is approved, you can always file the I-140 under EB3 category. Okay. Yeah, so you can directly file an EB3. You don't have to first get an EB2, then an EB3. We do this all the time. And normally what I want to do is, once I get the EB3, I will also file another I-140 for EB2. That way I've got both covered. I can't give you a checklist of documents required. I don't have any public list for that. In fact, it's tricky to downgrade. Whenever we look at a downgrade case, whether it's our filing or somebody else's, we have to review the entire file just to make sure there are no errors or omissions that will become a problem or become an issue when it surfaces during the downgrade. So it's not something I can advise you in the abstract. Star 5 if you have a follow-up question. What are the tentative charges? You can send Sumanji an email about the charges. Suman, S as in Sam, U, M as in Mary, A, N as in Nancy. She can respond to you. Suman, S-U-M-A-N, @immigration.com. She's our VP Operations for Legal Affairs. Okay. All right. So we are done with all the stated questions. Please go ahead, answer. I'll answer any question from anyone. Press star 5 on your phone. Anyone has any question? Okay, so let's see. So far I've got only one question. Very good. And that's excellent. That means you folks already have the answers. Good to know. Let's go with the hand that was raised. Area code 267. Where are you calling from?
Hi, Rajiv. I'm calling from Philadelphia. I have a new question.
Go ahead.
I don't think I heard you. Would you
Go
this
ahead.
for new questions?
Yeah, all new questions. Any question. Now I answered all the posted questions, so we are open to any questions now. So go ahead, please, sir.
Okay, I have a couple of quick questions. I got my green card this year in early April. However, the date that's on the green card as far as a resident since is a year behind. So it's for 2020. It's the exact date that I got the approval on. It's
Right.
just not 21. It's 2020. Do I need to get it corrected?
Oh yeah, absolutely. Get it corrected. And it shouldn't be difficult. I don't remember exactly what the process is. Hello? Can you hear me? Hello, can you hear me? Oh, it looks like I got disconnected. Let me call in again. Yeah, sorry about that, guys. We had a power fluctuation. Can you hear me? Can you all hear me? Hello? Oh, okay. It looks like we had a power fluctuation on our servers. So everybody got logged out. Anyhow, I guess we'll take up any other questions. There was only one person who had a question. So we'll take it up again in a couple of weeks when we talk. Good talking with all of you. Oh, okay, you're back. Philadelphia, you're back. Hello? Hello? Okay, it looks like we have some technical glitch, but we were able to talk and cover almost everything that was posted. We'll see you again in 2 weeks. Thank you, everyone.